Good afternoon. Welcome on in to another episode of From Day One. Let's head to court, courtesy of Law Talk with Mike.
Oh man, I gotta get together.
1001, People versus Ronald Simmons.
Ready. Good morning, Your Honor. John Angott appearing on behalf of Mr. Ronald Simmons. Judge, I'm here for attorney of record, Matthew Freiberg. Mr. Simmons, is it with your permission that I represent you this morning?
Yes, sir.
Thank you. Judge, we have worked out a plea agreement, that being between the prosecutor, myself, and my client. It's my understanding that upon this court's acceptance of a plea.
You didn't say the cat jumped on his wiener, did you?
To the count of consuming alcohol in a public place, the people will move to dismiss the older disorderly person urinating in public. It's my understanding also that the people are good with time served. Mr. Simmons has been in on at least one of these two charges, if not both, since October 10th. So counting that day, I believe he has 21 days credit.
Okay. Mr. Simmons, please raise your right hand.
The appearance is basically irrelevant, but that cat won't stop.
Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, go and put your hand down, sir. All right, Mr. Simmons, can you read, write, and understand the English language?
Yes.
Can you hear and understand me?
Yes.
Have you had a full chance now to talk to Mr. Angott, and are you satisfied with his advice?
Well, I couldn't hear you. Somebody come.
Sure. That's okay. Mr. Simmons, are you satisfied with Mr. Angott, the lawyer's advice?
Yes, sir.
All right. You're pleading guilty to possessing alcohol in a park place open to the public. That's a misdemeanor charge, carrying with it a maximum possible fine
Who doesn't?
of $500 plus costs and up to 90 days in jail, all at this court's discretion. Before you enter a plea, you should understand you have the right to represent yourself or be represented by an attorney. If you cannot afford an attorney, want to be appointed for you at public expense, you have the right to a trial, either by me or by a jury. At that trial, you'd have the right to confront, cross-examine, question all witnesses brought against you. You'd have the right to have the court subpoena witnesses on your behalf. You'd have the right to testify if you wanted to, remain silent if you wanted to, and no one could say anything about you remaining silent. As you appear before this court, you're presumed innocent of this charge, and your guilt has to be proven beyond a reasonable doubt. Sir, do you understand that once you enter a plea, you give up all those rights that I just said that you have at a trial?
Yes, sir.
Once you plead guilty, there'll be no trial. You understand that?
Yes.
Anybody promise you or threaten you in any way?
No, sir.
It's your own choice to do this?
Yes.
All right. Is it true that on or about July 24th of last year, 2020, that you were in, so it's the older case, that July 24th of the year 2020, is it true that you were in the city of Royal Oak and that you were in possession of open alcohol and open beer?
Yes, sir. I went and bought a beer from the store, and I did buy one beer, and I was drinking it at a concert out there that they had at that particular night. But I will agree to it. You're true.
Okay. Satisfied, Mr. Angott?
Satisfied, Your Honor. I thought it was a newer case. Thank you.
It's no problem. It's no problem. The urinating in public is
Of course he's satisfied. I'll leave it at that.
being dismissed. So that case is dismissed. Anything else, Mr. Angott, before this court imposes a sentence?
Nothing further, Judge. Thank you.
Mr. Simmons, anything you'd like to say before this court imposes a sentence?
No, sir.
It's a sentence of this court that should serve 20 days in jail with 20 days credit. I'll waive fines and costs. Close this out. Mr. Simmons, good luck to you.
Yes, sir.
Thank you, Your Honor.
All right, let me move you on, Mr. Angott, to Mr. Watson.
Thank you. So we're going to begin in case number 23-9503SM. Mr. Travis, you had an opportunity to review the allegations in the underlying complaint, nature of the offense, and the possible maximum penalties with Mr. Meyer.
We have. He would waive further reading. He would ask the court to enter a not guilty plea and request appointed counsel. We did discuss that he is aware of his rights relative to trial and his rights relative to remaining silent.
with regard to the bench warrant for the failure to appear?
He would acknowledge his failure to appear. He indicated that he did basically try and keep track of it, but then by the time he had gotten the notice, he was not in a position to have internet service at that time and was unable to attend, and that was basically, and now he's found himself for the past couple months down in Kent County Jail after that.
Don't worry, it takes a while, but this definitely gets worse. And in the meantime, you can just look at the defendant's fabulous hair.
It's 4 months now, yeah.
And do you currently have an outdate?
No outdate. I have a sentencing next week.
Is it a misdemeanor or a felony?
It's a felony.
Okay. So the court will recall the bench warrant and take no action on the failure to appear. In order to complete the petition for the court-appointed attorney, I do need to place you under oath and ask you some questions. Would you please raise your right hand? And you swear that the information you're about to give me will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you, and you're welcome to lower your hand. So Mr. Meyer, what is your mailing address?
Right now it's 225.
And that is the Kent County Correctional Facility?
No, nope, that's not. That's just where I get my mail at. Then the residential address will be different than that.
Okay. If the court were to mail you information or your court-appointed attorney, would you get it if we put it at 225 Commerce Street?
Yes.
Okay. Before you came to jail, were you working?
Yeah, I was doing private guitar lessons.
And what was your
He also would sell burritos on occasion.
average take-home pay?
About 400 a week.
Do you currently have any money in a checking account or savings account or any cash on hand?
Less than $100.
For real.
And do you own a vehicle?
No, Your Honor.
Do you have a phone number?
Yes.
What is that?
It's 231-499-5.
Pretrial conference would be scheduled for November 21st. The court will mail you the notice. If by chance you do complete your sentence there, it's an in-person appearance. So the court will mail that notice to the Commerce Street address. And if you are out of jail by November 21st, you must appear in court here at 9 a.m. For right now, I'm going to place you on a $2,500 10% bond so that you would be receiving credit for time that you're serving if you were convicted in this case of anything. It's not intended to keep you in jail. So if you are able to be released, make sure that you discuss with your attorney the situation, okay?
So what happens if I get time served on my other case on November 8th then? And there's the $2,500 bond.
So discuss it with your attorney. Mr. Travis, do you have any information that you'd like me to know?
Well, and speaking of Mr. Meyer, I believe it's a 2-year felony that he is being sentenced on, and he is hopeful that he'll get time served. I don't think he's seen a probation recommendation yet, so he's not really sure where it's going to go, but I think his thought is that there is high likelihood he gets time served.
No, there isn't. You'll see when this thing goes down. I really like attorney. What's it, Travis? He's really cool about it. He's like, yeah, what do you want me to do?
What was the offense that you were convicted of?
Resisting, obstructing an officer.
To this point, the defendant is so reasonable. I'm wondering why he's incarcerated at all. But you eventually see why.
You've had a number of assaultive convictions in the past.
I realize that, Your Honor.
Well, in this case, I'm going to leave the bond as I indicated. So it's going to be a $2,500, 10% bond. Conditions on the bond are you may not use nor possess any alcohol, any illegal substance, any controlled substance, including marijuana, any mind or mood altering substances, or any non-prescribed medication. You would provide a list of your current prescriptions to the district court clerk. You would take and pass, excuse me, twice daily PBTs proving you're not drinking. You would also submit to discretionary PBTs and discretionary urine screens whenever requested by a police officer or any court personnel, so you may not refuse. You may not enter a bar, casino, or any place that serves alcohol by the glass. You'll have no threatening, intimidating, harassing, or violent behavior towards any person. Be respectful of all court employees and care providers during the course of your case. You may not operate a motor vehicle without a valid driver's license, registration, and insurance, nor with the presence of any alcohol, any illegal substance, or any controlled substance, even that which might be prescribed to you. We will move on then to case number 23-9723SM. And once again, Mr. Travis, you had an opportunity to review the allegations on the complaint, the nature of the offense, and possible maximum penalties with Mr. Meyer. Is that correct?
Yes, Your Honor. You would ask the court to enter a not guilty plea, request appointed counsel.
Thank you. Based on the information that you provided, I will appoint an attorney for you in this case as well. I'm going to schedule the pretrial conference for November 21st. It would be at 9 a.m. It's an in-person appearance unless you are currently serving time. And we will make note for the court-appointed attorney to check out your situation. I'm going to set the same bond with the same terms and conditions in this case. The allegation, Mr. Meyer, is that you were a .366 at the time of the incident in this case. I believe that you do pose a risk to public safety, a risk to a named other, and obviously a risk to yourself.
Even though I've been in jail for 4 months?
Absolutely. Right.
Okay. Yeah, this is fucking funny. I'm done.
I'm glad you find it humorous. Thank you.
I think that's the judge throws in, I'm glad you find this humorous. Look at his attorney. He's like, I'm not defending this. I mean, you know, you saw what you saw, Judge.
And in this case, it's an outstanding warrant, so we'll want to recall the warrant. I'm guessing he's not going to get time served, just for your information. That would be my guess. Got a pretty good history.
Yep.
Holy wow. That's Metro.
Mr. Speed, if you want to step over.
I'm confused. It is me under the influence.
That's what I was informed.
Okay. Mr. Speed, can you hear me? Mr. Speed.
Okay, so this one here is Natalie D's fault too. So if you're keeping score at home, Natalie D's responsible for drunk and pussy, and Kristen's responsible for end of hearing freak out.
Well, he's not responsive. I was informed that he's under the influence, so he'll be remanded on the bond violation until we can conduct a meaningful hearing. Were we continuing? Did you have an opportunity to speak to him at all?
I did not, Your Honor. I had attempted to reach him in the previous, yeah, are we on the record? I don't think, are we on the record right now?
We were not on the record. On the record in the matter of the people of the state of Michigan versus Hakeem Speed, file number 23-03228FY. Appearance, please.
Jeff Brodowitz on behalf of the people, Your Honor. And good morning, Your Honor. Jared Austin appearing on behalf of Mr. Speed, who is appearing on Zoom from the downstairs lockup.
Okay, and today was the date and the time that was set for a probable cause conference. The matter is scheduled for preliminary examination on one count of possession of methamphetamine and count 2 of police officer assault. I also have a PA 53 bond violation. My indication today was that he was taken into custody on the violation. However, he is not in a condition to proceed with a court proceeding because he was heavily intoxicated. I do note here that at the time of his arraignment, he was listed as homeless. I'm inclined to believe that that prohibited you from being able to speak with him, and you've indicated you've not had communication with him at this time.
That is correct, Your Honor. The only address we had on file for him was the homeless shelter. There was a phone number on file that I attempted to call him at. I was not able to reach him. And then when I arrived this morning, I was informed that he was in lockup on a bond violation. It appears he was taken into custody on that sometime yesterday or last night. I went downstairs in the lockup in an attempt to speak with Mr. Speed. I was informed that he was not still in a condition to where I would be able to speak with him. So I have not been able to communicate with Mr. Speed. In addition to these bond violations, Your Honor, it appears likely that he is maybe going to be arraigned on additional charges from that, maybe sometime later today. Given that, Your Honor, I would ask the court to consider maybe some type of good cause adjournment so that we can have all of his court dates on this case, the new charges, and the corresponding bond violation to all line up.
For the record, Your Honor, yes, after Mr. Austin and I were informed of the bond violation this morning, I did check our system and found that there has been a new complaint signed against Mr. Speed for, I believe it will be 2 counts of police officer assaulting, resisting, obstructing. And so that mixed with the bond violation. It was the plan here today to ask for a good cause adjournment. I believe it would be only until next week, so that both PCCs and the bond violation can be addressed at the same time for possible global resolution, Your Honor.
Okay. And I've attempted to call Mr. Speed multiple times. He's present via Zoom. I don't know. Can you hear me, Mr. Speed? Can you hear me, Mr. Speed?
Mr. Speed, she's asking a question.
What is he talking about?
He's
Oh, he's rambling?
Everything's on footage. Right here.
Okay, I'm gonna find good cause to adjourn the
Okay, Junkie, go on. Why don't we go ahead and mute him?
preliminary examination, which was scheduled for next week due to our inability to proceed today because of his current state.